afternoon, everyone. Welcome to an AIA Contract Documents webinar on new industry standard contracts for home builders. Just before we begin, a couple quick disclaimers that none of the material we go over today should be acted upon as legal advice. We'll be going over some standard form contracts, but if you have anything that you think requires any legal attention, we do encourage that you reach out to a local attorney for anything like that. Another quick disclaimer that this presentation is protected by copyright laws. So before we begin, I just want to make a quick note, first of all, that everyone who's attending today will receive a follow-up email from AIA Contract Documents where you'll get access to the slides from today's presentation as well as the recording, so you can refer back to that at any point. And again, that will be via email following the presentation by the end of the week, I would say. And then also to get us started, I want to just do a quick kind of poll on the audience here to see who we have in the audience. So if you can, as an attendee, you should see a little raise your hand icon in your GoToWebinar box. If you're an attendee, can you go ahead and virtually raise your hand if you're a home builder yourself? All right, so it looks like we have some home builders coming on. Now you can go ahead and put your hands down. And now raise your hand if you're not a home builder, but you're somebody looking to build a home or hire a home builder. All right. Some of those as well, not quite as many as home builders. And then finally, those of you who are looking to build a home or hire a builder can put their hands down. Finally, if you're a design professional, go ahead and virtually raise your hand there. All right. All right, so it looks like we have a little bit of everything, and that's good to know. We're going to be going over, of course, some relevant material. And with that, I'm going to hand it over to the experts on that material and our presenters who are going to take you through the presentation today. So, Susan and Michael, I'll hand it over to you.
Thank you, Sarah, and good afternoon, everyone. Thank you for joining us today. I'm Susan Van Bell. I'm an attorney, and I am currently a consultant, but I was previously with the AIA for 12 years, most of that time as Senior Director and Counsel for the AIA Contract Documents program, and I did help work on the development of the documents that we will be talking about today.
And I am Michael Bell, no relation to Susan, and I am president of Bell Architecture in New Orleans, and we specialize in single-family custom homes. Also spent 6 years in the legal profession, 3 years at law school, and then practiced construction law. But I ultimately decided that I prefer to design and build homes. But I did remain fascinated with the juncture where design and construction meet the law, and especially contracts. And that's why I've spent over 12 years on AIA's Contract Documents Committee, helping to write the legal documents used by the design and construction industry. I was chair of AIA's Documents Committee in 2017 and 2018, and I extended my stay on this committee really for the purpose of completing the documents that we'll discuss today and some other documents related to residential construction, which will be out soon. Next slide.
So before we begin talking about the two documents that are the main focus of our presentation today, I just want to briefly talk a little bit about the history of the AIA Contract Documents program. I don't know how many of you are familiar with our program, since the documents we're talking about today are the first two that we've actually published that are specifically geared towards home builders. We've been publishing documents, as you can see, for over 100 years, and over that time period, we periodically update them to keep up with changes both in the law and in practice. A lot of the language used in AIA documents and the terminology has been accepted in the construction industry as, kind of the standard terminology. The documents are drafted by a committee of architects. That's when Michael talked about being on the committee. Volunteers who give a lot of their time to assist the AIA staff attorneys in drafting the documents. And then in addition to the committee and the staff attorneys, we have outside attorneys, insurance advisors, and then we get input from industry stakeholders. So, for example, we're talking about the home builder agreements today, and we did have some home builders review and comment on these documents for us so we could get, input from the people who really have a stake in them. We now have almost 200 agreements and forms, and that's because over the years, the complexity of the construction industry has grown, and now there are a lot of different delivery models and a lot of different issues that need to be addressed in these documents. Next slide, please. So the objectives when we draft these documents is to, we call ourselves the industry standard and to keep them that way. And the reason the AIA documents are considered the industry standard is because of the volume of history and precedent established around the concepts in these documents and the language that we use. And every time we release new documents, the AIA gets a lot of attention from the industry, either with what we've come out as a new document or what we changed in a document that we've revised. So the fair and balanced, the balanced competing interests, and putting risk where it's best managed, those are all best practices in drafting contracts. We try to put risk in the hands of the party that can best handle that risk. A lot of that is done through insurance, but also through contractual provisions that bind the parties to do certain things. And then, of course, the scope of each party's responsibilities. Next slide, please. So today we'll be talking about our two new home builder agreements, which we're very excited to have published. In fact, they were just published a few days ago. One is the A111, which is the agreement between the owner and the home builder for construction of a single-family home, and the A112, which is the agreement between the owner and home builder for design and construction of a single-family home. As I said, these are the first documents directed specifically toward home builders. We already have design bid build residential documents and design build residential agreements, and those are popular and have been used in residential construction quite a bit. Some of you may have already seen or used A145 2015, which is an owner design builder agreement for residential, and the two documents we're talking about today were really sort of based on that. So we're going to start talking about the A111, which is the construction-only agreement. And let me mention, we have an hour-long program and a lot to cover here, where really we'll only be talking about, the main issues that are addressed in these documents. There are a lot of other things that we just don't have time to get to today, but the documents are available, and you can go onto our website and see samples of them. And then you could see the items we haven't had a chance to talk about today. Next slide, please.
So that long title you just saw, really simplified, it just means that it's a contract that a home builder and their customer, the owner, signed to build a new home. It's not a contract for design. It's only for construction in this particular document. And I'll add that the AIA has always used the term agreement rather than contract. You'll catch me using both of them, but there's really, essentially for our purposes, there's no real difference there. In this situation, for this A111 document, the parties, it's presumed that the parties will obtain drawings from somewhere else, an architect or a draftsman or off the shelf somehow. But we don't anticipate that the provider of the drawings and specs, if applicable, is administering the contract. Administering is what we call in this business what an architect does relative to the contract when an architect is involved through construction. So there's no architect, there throughout from beginning of construction till the end. Also, for everybody's sake, we want to make sure nobody is stealing any drawings and violating copyrights. So this document includes a provision that whichever party is providing these drawings, whether it's the home builder or the owner, warrants to the other party that it has permission to build from them. So ultimately, the one who is violating copyright is the one who would be responsible in the end if such a scenario happened. But like all good contracts, this agreement, it goes way beyond this is what you pay and this is what you get. This was basically the agreement really sets out a roadmap for a project. It's really educational in a sense, especially for the homeowner as to what to expect as the project moves forward. But it also addresses many eventualities that you hope will never come to pass, such as termination and what type of legal dispute resolution you'll use. But they're important to have in the documents so they can be set out now rather than having attorneys spend a lot of your money arguing later about what should govern that was not included in the original agreement. Next slide. So at the front end of this agreement, the user fills in the fundamental information about the project. That includes who the parties are, the names of any consultants, like a structural engineer. This is all in Article 1. Then the user lists what makes up the agreement. That is what's included in the contract documents. And a fundamental thing that's in the contract documents, or the initial one, is of course the agreement itself. But drawings and specifications can also be filled in as part of the contract. And during the project, any changes that the parties agree upon also become part of the agreement. They of course can't be listed here because they haven't happened yet, but they ultimately become part of the agreement. And there's also, a place where you can list any other documents that the parties are saying, hey, this is what we've agreed to. For example, a list of allowances or allowances for the selections that will be made at a later date. Next slide, please. So as you probably know, building a home is in many ways different than building a commercial structure. The legislatures around the country have long considered that buyers of homes need special protection when they're purchasing a home. These consumers are purchasing something very expensive, and more often than not, they're only going to do this once in their lives. So legislatures have felt the need to protect them. And the laws on this vary widely from state to state. Like here in Louisiana, we have the New Home Warranty Act, and it is quote unquote the exclusive remedy for aggrieved homeowners. But this law and similar ones, this law requires that the home builder notify the owner of the statutory remedy and of the procedures that must be followed. For example, if a homeowner, after the final payment's been made, homeowner's living in their home and then there's some persistent leaks, the owner must write the builder regarding the complaint within 1 year of knowledge of the problem. But be careful. If you as a builder fail to notify the owner of what those procedures are, you might just waive your rights to the defense of claiming that the owner didn't follow proper procedures. So there's laws that are important to know, and in your jurisdiction, these consumer protection types of laws, and there may be other statutory requirements. And here in Article 2 is your chance to include the law or reference the law or put in whatever your jurisdiction requires of you to have in your contract. So that last item there, it's good also to have and reference any other requirements imposed by the outside entities like an historic district or maybe a homeowners association, which might, for example, limit the hours you can work in the project. So it's good to establish all this up front in the agreement. Next slide. So of course, this is in Article 3. Every owner wants to know when the work will be finished. And you'll want to agree upon when you will be substantially complete, which is defined as when the home is complete enough that the owner may move in. This is not final completion. The difference between substantial and final completion is important for a few reasons. One being that you'll want some substantial completion to be a payment milestone. You can likely agree on when the home is ready to be occupied, but final completion is usually a little different and more difficult. You won't want a significant payment held up while you quibble with a homeowner who covers their home with Post-it notes indicating what he thinks needs to be corrected. And no, I don't see anything here that needs to be corrected either in that photograph. Next slide, please. So contract sum is covered in Article 4. Most new homes are going to be built for stipulated cost, but you may write in any other alternatives you can think of. And the agreement, of course, includes a place for you to fill in the contract sum. You may also fill in the agreement the allowances or attach a list of them to the agreement. I'll say that we always expect allowances for appliances, plumbing fixtures, and the like. Typically, because the elections haven't yet been made, I think that's the traditional use for allowances. But I think lately we've seen some management of risk of price escalations through the use of allowances. I've seen lumber packages recently as an allowance, and in this possibly inflationary climate, we may find more and more uses for allowances in that regard. But another thing you can include here is the assumptions, exclusions, clarifications there on the bottom point there. And example of that is you may want to memorialize that your price does not include the pool and maybe the deck around it. I find some of those kind of get to be gray areas, and these are the kinds of things you can give some definitiveness to in the agreement, so there's no misunderstanding about it later. Next slide, please. So also in Article 4 is the provisions for the payment process. We typically see in these types of projects payments based on milestones, and there's a fill point in the agreement for establishing the payment schedule and identifying those milestones. If you want a deposit for your work, which we sometimes see, it would be included in this payment schedule. I'd suggest again that the substantial completion should be one of those milestones. You also will want to fill in the number of days within which the owner is required to pay after she receives notification and documentation that the payment is due. Another important point to cover. And the agreement also provides any lenders a place to reference any lender's payment requirements as well, as a lot of these homes will have a lender involved. So next slide, please.
Okay, and before I go over the insurance, I just want to mention one more thing about the payment process. If any of you do use any of our other contracts or other owner-contractor agreements use a payment process that involves payment applications submitted at 30-day intervals. But for these documents, we developed a different payment process, recognizing that, the use of construction milestones is more typical for these types of projects rather than a 30-day payment application. So just going through the insurance, and these are pretty standard insurance coverages. It's pretty much the same as what the AIA has in other owner-contractor agreements. There are fill points where you would fill in the minimum limits for each type of coverage. And so for the home builder, the required coverages are the commercial general liability, auto liability, workers' comp, and employer's liability, and those are at statutory limits. Builder's risk, and then there's a fill point if, for some reason the project requires the contractor to cover some other type of insurance as well. And then the owner's standard coverages would be property insurance and liability insurance. In some jurisdictions, contractors are required to, publish their insurance coverages and licensing information on, a governing agency website or something like that, so that it's public information that the clients can look up. And I'm sure if you're in one of those jurisdictions, you're aware of that as well. Next slide, please. Next slide, please. Dispute resolution. I mean, this is not a topic anybody wants to think about going into an agreement. Obviously, you're hoping the project will go smoothly and you don't have to go to any kind of dispute resolution. Nonetheless, it's a good idea to think about it in advance and agree on what you will do if, you do encounter this kind of situation, because it will just make it go a lot more smoothly at that time. I mean, let me mention, these contracts, and hopefully whatever you're currently using, you're going to include a lot of things that may never come into play, but you want these provisions there if you're in a situation where they do come into play, and that's part of how it protects both parties, so that you can go right to the contract and say, okay, this is what's happening, this provision addresses this situation, and it's spelled out for you. So as far as dispute resolution, the document has checkboxes, and you can select arbitration, litigation, or you can fill in something else as the method of finding dispute resolution. The difference between arbitration and litigation, some people favor one, some people favor the other. In construction, one advantage of arbitration is that you can get an arbitrator who is knowledgeable about construction, which is helpful as opposed to going to court and perhaps getting a judge or jury that really don't know anything about the construction industry. I would say one note of caution is that, as Michael was discussing earlier on, there are some jurisdictional requirements specific to residential construction, and some jurisdictions are really viewing it more in the framework of a consumer protection type of situation. And so in those places, sometimes arbitration is not really favored. So you would want to know how that works in your jurisdiction. And then the choice may also depend on the cost and the complexity of the project. So, most other AIA documents require mediation before going to arbitration or litigation, partly to try and streamline these documents a little bit. We did not include that, but also because, as sort of a practical matter, if you select arbitration and you're using either of these AAA rules, they're going to have you go to mediation first anyway. If you file a lawsuit, typically now, if you file a civil case, the court is going to have you do court-ordered mediation before there's a trial anyway. And so most of the time, you're going to end up in mediation. And then the other thing is that hopefully, if you do have a dispute in some of these projects, the amounts are small enough that you could just go to small claims court. And so it wouldn't really make sense for the contract to require you go to mediation first if it's something you can just take to small claims court, because you have to pay for mediation. So we do specify in the documents that arbitration is governed by these AAA arbitration rules. The home construction rules, which really were developed by the AAA for, residential construction owner-contractor disputes, has limits so that, for example, it's only claims up to $1 million. And so if you're over $1 million, then that would kick you into the construction industry arbitration rules. So that's why we put one or the other. Next slide, please. Termination. This is another one you don't want to think about when you're going into a project. Specifically, it's hard in these residential projects to think about these kinds of things. You want to have, it's a situation where the owner and the home builder want to have, kind of a close relationship. I mean, a family home is a huge emotional investment for the client. and you want to be working together and cooperating to get the project done. And so it's hard to say, well, what are we going to do if we have a dispute? What are we going to do if one of us has to terminate? But, that's part of why, again, having these provisions in the agreement, it kind of helps get rid of that emotion. And it's just, okay, this is what happened. This is what we're going to do. And so, as Michael mentioned earlier, the agreements are also kind of a roadmap for, how to handle things. And also, in many instances, to help educate your client about how this kind of project works and what the issues are. So anyway, as far as termination, we have 3 different types. Obviously, you would never use all of them, but there are 3. First, the homeowner can terminate, the home builder can terminate the owner for non-payment after 30 days past when the payment is due, with 7 days notice to the owner. You can terminate, and if that happens, compensated for work executed and costs incurred due to the termination. And then we have termination for owner termination for convenience as an option, which, that's where the owner doesn't really need to have a reason. And that's something everyone wants to avoid. And, so again, this kind of goes back to the nature of the project and the owner-home builder relationship. You really don't want an owner to terminate you just because you aren't getting along or they don't like you or something like that. But if it were to happen, we have included a provision for a termination fee. So the home builder would be compensated for the work executed and costs incurred due to termination. But then you can also negotiate a termination fee that you can fill in. And, that's partly to help discourage an owner from terminating for convenience, because they'd have to pay the fee if they do it. And then also to help compensate the home builder for, they're going to have additional losses from not being able to complete the job. And then the last one is the owner terminating for cause, which, of course, the owner can terminate for cause. And there's a list of reasons in the document, including things like failing to supply properly skilled workers or proper materials, failing to pay your subcontractors, disregarding, relevant laws, or being guilty of a substantial breach of a provision of the contract documents. And if there's a termination for cause, the owner's entitled to finish the work, and then the balance due to the home builder would depend on how much is left of the contract sum and whether or not it costs the owner more or less than the remaining balance to finish the work. Next slide, please. So now we're going to talk a little bit about owner responsibilities. As I mentioned, part of what these agreements do is delineate the responsibilities of each party. Financing, we do have a provision that requires the owner, at the written request of the home builder, and this would be prior to commencement of the work, to provide evidence of financing and that any contingencies for financing have been satisfied. The home builder does not have to start the work until the owner provides the evidence. And, that's reasonable enough. Obviously, a home builder wants to know that the owner has the funds to pay for the construction of the house. Next slide, please. Information. This is kind of like what Michael was talking about earlier, those fill points that ask for certain information. And then in the owner responsibilities section of the document, there are requirements for, the owner shall provide these listed types of information. These are essential pieces of information that the home builder is going to rely on. So it's important for you to go through this with the owner and make sure they're providing you with all of this information. And that way the builder is protected if something goes wrong based on information the owner should have provided and didn't provide. And then because this document is specifically for residential construction, we did include items such as the homeowners association requirements, site covenants, and those kinds of things. And then the final bullet on consultants, it says services of geotech and other consultants if requested by the home builder and reasonably required. Some of these projects are going to require a geotechnical report and others aren't. And so that's, one where, the home builder would evaluate whether there are any consultants needed and ask the homeowner to provide them. Next slide, please. So rejection of work, this is a big topic, and we had a lot of discussion about it. So the document says that the owner may reject work that does not conform to the contract documents. Well, the home builders have undoubtedly had many experiences where the client may have unreasonable expectations. And, owners may not know what it means to say that work doesn't conform to the contract documents. So we really had a lot of discussion about how to try to put some limits around this concept. And what we came up with was we added this reference to a standard for the performance or the quality of the work. And then if that standard is not met, the work would be considered to be non-performing. If the owner does reject work that is non-conforming, then the home builder would have to correct it and bear the cost of correction. And I think Michael can provide us with some examples of the kinds of standards that we're talking about here.
Yeah, this is, I think we all know this can be a particularly challenging issue for home builder homeowner relations. My typical practice, we are the architect involved, and we are obligated to be fair and make these calls as to whether something should be rejected or not. And but when there's not us as the third party, not an architect as the third party, it can be a challenge. There are some unreasonable expectations that some clients have. Any of you are home builders, I'm sure you know what I'm talking about. But standards can help. And one of them I'm sure you builders know about is that the NAHB publishes a very comprehensive performance guidelines, which covers all the different trades and components of a home. And you may want to reference that. If there's sometimes it's necessary to dig deeper on a particular trade, and the industry associations can do offer guidance as to tolerances and other criteria for determining what would be an acceptable performance. Entities like the Tile Council of America and National Wood Flooring Association, which is one that we had recently to refer to resolve a little bit of a disagreement as to what was acceptable. There's a lot of subjectivity in these sorts of things, and standards can help. That's next slide.
Owner selections. This is fairly straightforward. I mean, there are things like owners going to pick. Now, the A111 is geared though towards a project where, we feel like it's going to be a slightly less involved owner as a client in many instances. I mean, if they're buying some, off-the-shelf type of drawings and they hire the home builder, just to build the house and don't want a lot of involvement in the project. So, maybe they wouldn't have a lot of selections, or maybe a situation where a home builder has, a few models of a home for the owner to pick from, and then, certain things that the owner would select, but maybe a little bit more limited than in a fully custom type of house situation. Nonetheless, we want to be sure that the owner makes the selections in a timely manner so the project doesn't get held up. And so we did put in a provision that the home builder would provide a schedule, and the schedule would list the products and materials to be selected by the owner and the samples to be provided by the home builder. And then allow the owner reasonable time to review and consider the selections, but then the owner's, approval wouldn't be unreasonably delayed and keep the project moving. Next slide, please.
So switching from what the owner is obligated to do to what the home builder is obligated to do, Article 7 in this agreement, it's entitled General Provisions, and it generally sets forth what a home builder is required to do. And I think that if you read that first bullet point there shouldn't be any surprises as to those obligations. And you're also required, of course, to supervise and direct the work. And nobody but you as home builder is responsible for how the work is done. This is there's a phrase in here we see in just about every design and construction contract, and that's that the builder is solely responsible for control over construction means, methods, techniques, sequences, and procedures, and for coordinating all portions of the work. You'll see that in every one of our construction contracts, of which this is one, as well as the design contracts basically say that this is the responsibility of the builder. So next slide. So as I mentioned before, you need to know your state's consumer protections laws as to what you warrant, and as to the notice you must give your owner, excuse me, as to proper procedures that he must follow to avail himself of these protections. There's additionally, these are home builder standard warranty obligations are listed here in the agreement. The first one is that you need to be, or required to be, using proper materials, which essentially means new materials, nothing repurposed or anything like that. That the work must be free from defects, and that the work conforms to the contract documents. We defined those contract documents earlier, but the drawings are the most obvious of what the work needs to conform to. And so home builders warranting all of these in addition to whatever the statutory requirements are in the jurisdiction of the project. So next slide, please. So permits and fees, the agreement provides that the home builder pays for the permit and associated fees, but you'll of course want to include this or an allowance for this in your bid or your estimate. I mean, essentially the owner essentially pays for it, but you should have it included because it shouldn't just be a surprise expense for the owner. We all know that in most locales, an inspection falls far short of proving work was fully and properly performed. But that second bullet point there about the requirement to provide copies of permits, licensing, and inspection approvals, basically they go towards showing that the contractor, the home builder, is due the amount the home builder is claiming is due, and that can sort of just help demonstrate that the payment is due. Plus, I mean, they're paying a lot of money for this home. They should have these kinds of documents in support of, or as a reference for their home. Next slide. So changes. We said when the owner and home builder agree on changes in the work and in writing, this new little agreement as to the changes becomes part of the contract documents. But if the cost of the change is an issue, in that second bullet point there, the parties the parties can't decide how much it should cost, but they want to go forward. They can't agree to keep moving forward with the work because the agreement here provides for how the cost will be calculated. And that's, of course, actual cost plus overhead and profit. But of course, ideally, you want to resolve the cost before you move forward. But we all know that, the realities of schedules are such that you just kind of keep going, and you don't really have, you often don't have time to stop and calculate what something is going to cost. So this allows for that expediting of the work. So when sometimes, there's concealed or unknown conditions, And when these surprises are encountered and they can't be anticipated, Susan talked earlier about we try to put the risk on the party that can best bear it, and this should not be on the home builder. The owner bears this risk for these kinds of surprises that nobody can anticipate. And so the contract time and sum or both have to be adjusted for running into these surprises. Next slide, please. So regarding completion, we talked about completion a bit earlier and said substantial completion is when the work is sufficiently complete in accordance with the contract documents so the owner can occupy the work. So what happens then is at that point, the home builder prepares a punch list, list of items to be completed. And then the owner gets an opportunity to add to it. And they will, of course, do that. The home builder prepares the certificate of substantial completion and attaches the agreed upon list. And, AIA does have a document that is a good form for this certificate. It's the G704. But this certificate's, its primary importance, in addition to establishing the date in itself, is that it triggers the warranty periods and lien periods. And you want to start these periods to run on a date certain rather than at some later date that can be argued about by expensive attorneys. At substantial completion, the owner takes over responsibility for utilities, insurance, etc. And then final completion is achieved and final payment due after the punch list is complete. After the home builder submits to the owner releases and waivers of liens as well. Next slide, please. Susan?
I'm sorry, I was on mute.
Okay.
Thank you. Now we're moving on to A112, which is the agreement for both design and construction. And again, let me just mention, because we're really only going to talk about the differences here, the design portion of A112. There are other provisions in both documents in the general conditions that we just don't have time to address today. Things like hazardous materials, access to the site, and other important items that you'll see if you take a look at samples of the documents or if you use the documents. Next slide, please. So A112, as I mentioned, is, the difference between A111 and A112 is that A112 includes the design process, and it's really more of a design build agreement for home builders that provide design services as well as construction services. And if any of you have used our design build agreement for residential, which is A145 2015, this document was substantially based on that, but of course that document's 2015, so this document is more updated. But I would say that Michael Bell, our co-presenter here, worked on the A145 back in 2015, and so Michael has worked on these documents, through the whole progression of them. So basically, in A112, the home builder does provide the design and the construction. The design work could be, provided by someone you have in-house or an architect that is retained by the home builder. And this is geared, as I was saying before, that A111 is geared towards a client that maybe is not as involved in the project. A112 is really geared towards a client that maybe wants to be more involved. So, they want input into the design and maybe more selections and that sort of thing. Again, most of the provisions in A111 are also in A112. So things like, dispute resolution, termination, rejection of work, all those topics that we covered in A111, same in A112. A112 includes a construction phase amendment, which is executed after the design proposal is accepted, and we'll talk about that a little more in a few slides. Next slide, please. prior to execution of the construction phase amendment, here we're talking about pre-construction services, and so that includes the design work. There's a fill point for compensation in case construction does not go forward. And also there's a fill point because we recognize that this phase is handled very differently. You know, different home builders do this in different ways. I mean, some don't even charge to develop documents because they want to do the construction. Some might charge by the hour, some might charge a flat fee. And so there's just a fill point where, you know, the home builder puts in their charge or the way they're going to bill for pre-construction services, or leave it blank if they're not going to. But then, you know, if you do develop the design and for whatever reason the homeowner just decides not to move forward, this, you know, you would get paid if you had filled the amount into that fill point. So the way the design process actually works is that the owner would provide project criteria, you know, their design requirements, 2-bedroom, 3-bath, whatever, physical characteristics, their budget, milestone dates, you know, all the important items that you need to be able to develop the drawings. And then the home builder provides a preliminary design for the owner to approve. The home builder then prepares a proposal, which will be based on preliminary design and the information that would be included in the construction phase amendment. So that's things like contract sum, contract time, et cetera, which we'll go over. And then if the owner and the home builder agree on that proposal, the construction phase amendment is executed, and then you move on to the construction portion of the project. I think Michael can kind of flesh out a little bit on the design portion of it here for us.
Yeah, thanks, Susan. Yeah, I would just mention it's, you know, the emphasis is on that it's preliminary design. You know, this is the design portion of the agreement, but it's preliminary design. And as Susan said, some home builders, you know, you may want to even give this away, but you're not giving away the construction documents as well. I mean, hopefully you get paid for it, but it is a business decision that, you know, as to whether some people treat this as a loss leader type of thing. But there is that fill point for compensation for this design work, and you can charge for it. But, you know, I think it's also kind of a nice relationship building thing or marketing thing. If you put a 0 in there in the form, it just shows, it demonstrates what you're giving away, which can be a good thing. But it's preliminary design, and then Susan's going to talk about after the construction phase amendment, and there's a little bit more, there's more design to be done after that. Next slide, please.
All right, so once you've gotten through your preliminary design and your proposal, then you would fill out the construction phase amendment, and then when that's executed, becomes part of the contract, and you can move forward to the construction. So that includes a lot of the items we've already gone over with respect to A111, and basically it's the same. A111, of course, doesn't have this information as an amendment because it is purely a construction document, body of the document. But in A112, this construction portion is sort of, you know, it's an exhibit, as I mentioned before, because that way, if you don't move forward, you have your pre-construction compensation in the agreement. You don't move forward, that's the end of it. If you are moving forward, you sign this amendment, and then you have your contract sum, and everything else is included in the amendment. And I think Michael's going to flesh this out a little as well.
I would just add that, you know, I think of this amendment is essentially like the A111, as Susan was saying. This is the construction portion, but it's more. It's post preliminary design. In other words, there's some of the construction documents, construction drawings will remain to be done. You know, I'd envision foundation plans and you know, wall sections and things like that would have to be done after the construction phase amendment. And this is design build. It's not design then build. And so, it's anticipated that the drawings will be developed to where they can be built from, and a permit can be obtained based on these drawings. And then the key is here: the owner gets the opportunity to review the construction drawings to make sure that that looks like what we agreed you were going to further develop when we signed the agreement, the construction phase amendment. And even if the owner doesn't catch deviations, and if something was done that was inconsistent, and something in the construction drawings was drawn that was inconsistent with the preliminary design, it does not relieve the home builder from the obligation to make sure that what the homeowner is going to build complies with the preliminary design, that the two parties agreed upon before they signed this amendment.
Right, and Sarah, before we move on to the next slide, I think that in the payment section in this document is handled as A111, which is, the parties can create their own list of construction milestones, and at those milestones is when payments are made. So you could put in that list here, preparation of construction documents. That could be your milestones, and then the owner's, has a payment due at that time.
That's true.
Next slide. So that's, the basic overview of the two new documents. And I just wanted to mention a few of the other documents that the AIA publishes in case you're new to looking at the AIA documents program. And if you do other work besides, residential homes, if you do any commercial work, or if you're working on any projects where the owner's hiring an architect and hiring a contractor, here are some of the other documents we have available. A1 is longer, A101 is an abbreviated form, A105 short form. And then, as Michael mentioned, the certificate of substantial completion, we have a series, G series, that is construction administration or project management form. So that has things like payment applications, certificate of substantial completion, change orders, and a lot of other helpful forms. With respect to the documents we discussed today, I also want to mention that we are going to have a couple more webinars. One is next Thursday, June 24th. That one is legal considerations for home builders. And we'll be covering a lot of the same information that we did today, because obviously you can see how they're legal issues. But if you want to, hear about them again, or if you know anyone who didn't attend today who might be interested in learning about these documents, they could attend next week. And then on July 8th, there's going to be another webinar on how to fill in the fill points in these documents. So that's more of a hands-on, practical. The presenters will go through the documents and say, okay, here you have to fill out this, here you have to fill out that, and they'll kind of walk you through how to do it, which might be helpful. Next slide, please. So I'm sorry, actually I do want to mention as well, while I'm talking about the webinars, these two documents are new documents in a residential suite that we're developing, these two home builder agreements. In a few weeks, we're going to also be publishing two new custom residential agreements, one between the owner architect and one between the owner contractor. So you might want to take a look at those. And we are also in the process of developing a new agreement to be used in remodeling. You could use A111 or A112 for a remodeling project, but really they're kind of long and maybe have more than you need for remodeling. And so this remodeling document that we're developing will be a bit more streamlined, and it'll include some provisions that really are more specific to remodeling than to new construction.
Susan?
So how can you get I'm sorry?
I was just going to add that the custom residential documents you mentioned, I just didn't want anybody to spent time looking for them sooner than they were available, but they're scheduled to be available after August 3rd.
Okay, thank you, Michael. You're right about that. And we don't have a publication date yet for the remodeling agreement, so you'll have to watch for that. So how can you get these documents? You go on the AIA website, you can see the screenshot, there's a purchase page. They come as a basic single document, which is a locked PDF, and you can just fill in the fill points in that version. Custom single document, which is a template of the document that is fully editable, so you can change the provisions if you want to, and then an unlimited annual subscription, which is access to our entire the AIA's entire documents library, and it would be all editable templates. Next slide, please. And resources and contact information. The AIA has all kinds of stuff out there to help you, learn about the documents and use them. The Learn and Help web pages. There's a YouTube channel that has a lot of little videos now that people are enjoying watching about, not only about the documents, but about other issues in construction. If you have questions about the document content, you can contact our docinfo service. If you have questions about, using the templates, you can contact our tech support service. And docinfo and tech support are very, very good about getting the questions answered. I will also mention that we have a set of FAQs also posted on the website for each of the documents we discussed today. So with that, I'm not sure if we may have time for one or two questions. If we can't answer a question for you today, please send it to our docinfo service and we'll make sure you get an answer through docinfo.
All right, thank you, Susan. Yeah, it looks like we have about 2 minutes left. So that's probably about enough time to answer one or two questions. Excuse me. So my first question that I have from the audience is that termination in a commercial construction project is the absolute last resort for various reasons. Is there any language in these documents to prepare owners for the ramifications of termination?
That's a good question. I think and let me say that, in all the AIA documents, there's a termination provision, and, that is in there. Again, it's one of those distasteful areas you don't want to really have to look at, but it's really necessary. And, I think, like I said, when I was talking earlier about the termination for convenience, putting in, if you put in, you can negotiate with the owner a termination fee so that, if they just decide they don't want you to continue working on the job, they know there's going to be, really kind of a consequence that this termination fee has to be paid. We're very specific and detailed in these documents about the types of terminations and the specific reasons underlying them, and then the specific remedies. What does the home builder or the contractor get paid in each type of termination scenario? So that's not something you're going to be arguing about if it happens, and hopefully it won't.
Yeah, it's very undesirable, obviously, and within the four corners of the document, all we can really do is give the procedures by which a termination would happen. But I'm sure there are plenty of resources out there that might help make the argument as to why that's very undesirable. Although it seems it would be common sense, but we appreciate that some homeowners may need their eyes opened a little bit about it.
All right, thank you, and Michael, Susan, both. So it looks like we've just rounded out the end of the hour. See a few questions here. Just to remind everyone, address those questions. You will receive the recording and the slides of this presentation from an email from AIA Contract Documents, so keep an eye out for that. I did see an audience question asking if we could provide a link to the NAC quality standards. We can certainly do that in the slide deck that we send around. And with that, thank you very much for your time today, Michael and Susan. There was a lot of great information. You guys are certainly the experts.
Thank you all
Thank you
for attending.
very much for attending.
Thank
All
you.
right, thank you.